Veuillez vous asseoir. La parole est à Monsieur Paul Rackler.
Mr. President, distinguished members of the Court, it is, as always, an honor for me to appear before you. Today, I am privileged to speak on behalf of the Federal Republic of Somalia. Professor Pele has meticulously taken you through the text of the MOU. He has shown you, based on well-established principles of treaty interpretation, that the MOU is not an agreement on a means for settlement of the parties' maritime boundary dispute, nor does it prevent the parties from seeking to have that dispute resolved by this court. My role today will probably not come as a surprise to you. As is often my fate, I am tasked once again with analyzing the evidence that is before you. I make no complaint about that. I know my place. And especially in this case, I'm content with it, because the evidence of what the parties intended when they executed the MOU and how they understood it as reflected in their practice is an important part of the case. It can be of great assistance to the Court in determining the proper interpretation to be given to the MOU. We say the evidence fully supports Somalia's interpretation of the MOU, which is the one Professor Pele has just given you. We do not invoke the evidence in regard to the object and purpose of the MOU or the context in which it came about in opposition to a proper reading of the text. We invoke it to confirm our reading of the text. That evidence falls into two categories in relation to two different time periods. First, the evidence of the parties' intentions at the time the MOU was signed in April 2009. Second, the evidence of how they understood and interpreted the MOU subsequent to its execution from then until the case was commenced at the end of August 2014. I begin with the evidence of the parties' intentions at the time they signed the MOU. An important fact is that the MOU was neither conceived nor drafted by Kenya or Somalia. As counsel for Kenya acknowledged yesterday, both the idea and the text came from Norway. The context helps explain what was intended. In early 2009, time was running out for coastal states to submit their outer continental shelf claims to the CLCS. Some states lacked the technical expertise to prepare these highly complex submissions. If they missed the deadline, their potential rights beyond 200 nautical miles might be lost forever. This was a particular concern in Africa. To address the situation, the General Assembly called upon UN member states, quote, to assist coastal African states in the preparation of submissions to the Commission regarding the outer limits of the continental shelf beyond 200 miles. Norway, to its credit, answered the call. It did so in several ways. First, it provided technical assistance to a number of coastal states in East and West Africa to help them prepare timely submissions to the CLCS. Second, because the Commission's rules of procedure permit states to block consideration of their neighbors' submissions merely by asserting the existence of a dispute, Norway facilitated and drafted agreements between and among neighboring states, committing them to refrain from objecting to CLCS review of each other's submissions. This was to allow the CLCS to issue recommendations on the outer limits of the continental shelf, with the understanding that these would be without prejudice to any boundary delimitation disputes. In West Africa, for example, Norway provided technical assistance to ECOWAS members in respect of their CLCS submissions, and also drafted and facilitated an agreement among them not to object to each other's submissions. As a consequence, even though Ghana and Cote d'Ivoire are now in litigation before a special chamber of ITLOS over their disputed maritime boundary, both have complied with the non-objection agreement drafted by Norway and refrained from objecting to each other's submissions to the CLCS. Norway played a similar role in East Africa. It signed on to provide technical assistance to Somalia, which needed its help. The deadline for the submission of its preliminary information to the CLCS was May 2009. Somalia at the time had no capacity to prepare its own submission. The transitional federal government was newly functioning. Its Herculean task was to create a viable state following from the collapse of governmental authority, 2 decades of chaos and civil war, and a militant insurgency which then controlled much of the country. Because of Norway's invaluable assistance, Somalia was able to submit its preliminary information in a timely manner. As it did in West Africa, Norway also sought to avoid objections from neighboring states that would preclude the CLCS from considering Somalia's submission. That was the reason Norway proposed the MOU. Like the non-objection agreement Norway brokered among the members of ECOWAS, Norway offered the MOU as a non-objection agreement between Somalia and Kenya so that the CLCS could review both states' submissions without objection from either one, notwithstanding their disputed maritime boundary. Norway had no interest in the boundary dispute itself. Its only concern was securing the non-objection of the parties so that their submissions could be properly reviewed by the CLCS. Kenya acknowledges that Norway, through its ambassadeur en mission spéciale, the late Hans Wilhelm Longva, drafted the MOU and presented it to the parties. Contemporaneous documentation shows that Ambassador Longva first presented a draft memorandum of understanding to the Somali Deputy Prime Minister on 10 March 2009, after previously discussing it with the chairperson of Kenya's task force on the delineation of Kenya's outer continental shelf. Both parties have appended to their written pleadings copies of the correspondence between Ambassador Longva and Kenya on the one hand, and between him and Somalia on the other, in regard to the MOU and its text. Significantly, there is not a single reference in any of the contemporaneous correspondence to settlement of the maritime boundary dispute or to the establishment of a method for resolving that dispute. Somalia proposed one change to Ambassador Longva's draft, and that was to the title. At Somalia's request, the words, quote, "to each other," were inserted so that the text read that Kenya and Somalia, quote, "grant to each other no objection in respect of submissions on the outer limits of the continental shelf beyond 200 nautical miles." As Professor Pele explained, both the original title and the final one reflect and are in keeping with the central object and purpose of the instrument, to secure the non-objection of each state to the CLCS submission of the other. The record shows that this is how the drafter of the MOU, Norway, and the 2 states that would be party to it, Somalia and Kenya, understood the object and purpose of the agreement. Ambassador Longva and Norway, in fact, took pains to distance themselves from and avoid involvement in settlement of the boundary dispute, and to separate that dispute as far as possible from the parties' submissions to the CLCS. At tab 5, and on your screens is an interview with Ambassador Longva, published in 2009. There, underneath his cheerful countenance, is his statement that following his return to the legal department of the Foreign Ministry in 2008, quote, "I am now responsible for a project relating to assistance to African coastal states in the establishment of the outer limits of the continental shelf beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured." He says nothing about having any responsibility for delimitation of boundaries, dispute settlement, areas up to 200 miles, or the exclusion of recourse to international adjudication. At tab 6, and on your screens, are further remarks by Ambassador Longva given in November 2009, this time in an intervention to the Pan-African Conference on Maritime Boundary Delimitation in the continental shelf. They shed further light on his and Norway's intentions. Quote, "I want to stress from the outset that the establishment of the outer limits of the continental shelf is a different and separate issue from the delimitation of the continental shelf with opposite or adjacent coasts. The establishment of the outer limits of the continental shelf is without prejudice to, that is, it does not affect matters relating to the delimitation of the continental shelf between states. Consequently, it is not necessary to solve issues of maritime delimitation between neighboring states before embarking on the establishment of the outer limits of the continental shelf." Neither Ambassador Longva nor Norway set about to solve the issues of maritime delimitation between Kenya and Somalia. Their only concern was in preventing that dispute from interfering with CLCS review of the parties' continental shelf submissions. Norway provided its understanding of the object and purpose of the MOU between Kenya and Somalia in a note verbal to the Secretary General dated 17 August 2011. You will find this at tab 7 on page 4 and on your screen. Quote, "In the Memorandum of Understanding, MOU, the parties agree that at an appropriate time, each of them will make separate submissions to the Commission on the Limits of the Continental Shelf, CLCS, that may include areas under dispute between the two countries without prejudice to the delimitation of the maritime boundaries between them. In this MOU, the two coastal states grant their prior consent to the consideration by the CLCS of these submissions in the areas under dispute. Furthermore, it is stipulated that the submissions made before the CLCS and the recommendations approved by the CLCS thereon shall not prejudice the positions of the two coastal states with respect to the maritime dispute between them, and shall be without prejudice to future delimitation of maritime boundaries in the areas under dispute, including the delimitation of the continental shelf beyond 200 nautical miles. In its final paragraph, it is stipulated that, quoting from the MOU, this memorandum of understanding shall enter into force upon its signature. Tellingly, in describing the object and purpose of the MOU, Norway skipped right over the penultimate paragraph and said nothing about settlement of the parties' maritime boundary dispute, stating only that their consent not to object to each other's CLCS submissions was without prejudice to their respective positions on the boundary. Norway did not describe the MOU as an agreement on a specific method or timetable for settlement of the boundary dispute. Norway made no reference to settlement of that dispute or to how such a settlement might be achieved. On the subject of delimitation, Norway's note verbal said only this on page 3 and on your screens, quote, "The politically most sensitive issues involved may be the unresolved issues of maritime delimitation between Somalia and neighboring coastal states. Norway takes no position on these issues other than laying as a premise for its assistance that such issues of maritime delimitations with other states not be prejudiced." The Court has no reason not to take Norway at its word. By its own description, in proffering and recommending execution of the MOU, Norway was not addressing or attempting to facilitate resolution of the parties' maritime boundary dispute. Rather, it sought only to ensure that the parties' submissions to the CLCS would be acted upon by that body. Norway's approach was thus to separate the parties' submissions to the CLCS from their maritime boundary dispute, so that the former could be addressed by the CLCS without implicating or prejudicing the latter. At the time the MOU was discussed and signed, no one, not Norway, not Somalia, and not Kenya, indicated that it considered the MOU to be concerned with settlement of the maritime boundary dispute. That intention is not present, not explicitly and not implicitly, in any of the contemporaneous records. Kenya's records confirm this. At tab 8 is the Kenyan Foreign Ministry's August 2009 internal memorandum regarding registration of the MOU with the UN. It describes the MOU as being, quote, in respect of submissions on the outer limits of the continental shelf beyond 200 miles. Nothing about dispute settlement is mentioned. Similarly, at tab 9, you will find a summary of Kenya's presentation to the CLCS in September 2009. There, the chairperson of the Task Force on Delimitation of Kenya's Outer Continental Shelf, the same person who was consulted about the MOU by Ambassador Longva prior to execution, is recorded as describing the MOU as, quote, a provisional arrangement of a practical nature whereby the parties undertake not to object to the examination of their respective submissions. Nothing about dispute settlement. The executive summary of Kenya's submission to the CLCS, an excerpt of which is at tab 10, also describes the MOU only as, quote, granting each other no objection in respect of submissions on the outer limits of the continental shelf. On the maritime boundary, the executive summary states merely that Kenya and Somalia will delimit their boundary, quote, pursuant to an agreement on the basis of international law. This is no more than a restatement of their mutual obligation under Articles 74.1 and 83.1 of UNCLOS. The MOU is mentioned in the same paragraph of Kenya's executive summary. Significantly, Kenya does not describe it as an instrument that addresses in any way the means to settle or reach agreement on the boundary. The contemporaneous evidence is thus conclusive. Kenya gave no indication that it regarded the MOU as imposing any obligations in regard to settlement of the boundary dispute. All of Kenya's statements from 2009 refer to the MOU solely as an agreement on non-objection to the parties' respective submissions to the CLCS, without prejudice to issues of maritime delimitation. There is nothing more than that. And the same is true for Somalia's contemporaneous statements. The transitional federal government was sworn in on 22 February 2009, just a few weeks before Ambassador Longva presented it with the draft MOU on 10 March. Senior Somali officials were informed of Norway's assistance with the submission to the CLCS at the same time that they received the draft MOU. For this reason, they assumed that the MOU and the submission were indivisibly connected to one another and that the MOU was necessary for the submission to be filed. In an email sent shortly after the 10 March meeting, the Deputy Prime Minister expressed his gratitude to Norway for, quote, doing all the work that we were supposed to do regarding the preparation of the preliminary information, and expressing his understanding that, quote, we must have the memorandum of understanding that Norway has prepared. This understanding was confirmed by the Minister of Planning and International Cooperation, who said that the Somali government believed it had to sign the MOU with Kenya in order to proceed with its submission to the CLCS. Thus, for Somalia as well as Kenya, The MOU was linked directly to the submission to the CLCS. It was not understood as an agreement on the means for settlement of the boundary dispute. In sum, the evidence surrounding the adoption of the MOU in 2009 fully supports Professor Pelle's reading of the text.